Good afternoon and welcome to our discussion on Connecticut paid leave. Today's conversation will address which employers must participate, who will be eligible for paid leave, and the resources available to support both businesses and workers. I'm your host, Vera Smith Winfrey, Executive Director of the Bloomfield Chamber of Commerce, and today's guest is Andrea Barton-Reeve, CEO of the Connecticut Paid Leave Authority. Welcome, Andrea, and thank you for being with us today.
Thank you, Vera, and thank you to the Chamber for having me this afternoon. I appreciate the opportunity to talk about paid leave. I will just jump directly into my presentation. It does take about 30 minutes. There are some slides that I think I just may skip so that we can have more time if there are questions, and we'll go ahead and get started.
Great.
We can see your screen.
All right, thank you. I'm trying to get it to do what it's supposed to do. Let's see. It's all these buttons to push, so I appreciate everyone's patience. It takes forever to get everything hidden and out of the way. All right. All right, so let's talk today a bit about understanding paid leave because that's really the focus of our time together today. All right. I'd like to tell you just a little bit about myself. My name is Andrea Barton-Reeves, and I am the CEO of the Paid Leave Authority. Before I came to Paid Leave, I was the president and CEO at HARC in Hartford, which supports people with intellectual disabilities and their families. I've been active in the community, but prior to my career as an attorney, I also worked at the insurance industry at Chubb in New Jersey. I do have an undergraduate degree in English from Rutgers, and I have a law degree from New York Law School. Today, we'll talk about the paid leave program by providing an overview, giving a brief review of the role of the employers, how people will apply for their benefits, how it might work in your workplace. I'll also talk a little bit about private plans and what those are, the registration process, give you some sense of additional resources that might be available to you, and then we can go into our question and answer session. The Paid Leave Authority was signed into law in July of 2019 by Governor Lamont. Its primary missions are to provide pathways to accessible paid leave benefits and to help employers and administrators and healthcare providers by giving them tools and training so that they can understand their roles in navigating the program. According to the statute, we have 5 primary responsibilities, and they include outreach and engagement, which is part of the opportunity to be here with you today, developing the policies and procedures that are needed to run the program. We also established the trust fund contribution rate, which is set at 0.5%, and we collect those contributions. We approve and audit private plans, which are opportunities for employers to offer their own version of paid leave pursuant to the law itself, and we administer claims for paid leave benefits. Here are some key dates that are of importance in the paid leave journey, I should say. So employers were asked to start registering in November of 2020. Contributions that the 1% of withholding of wages should have started in January of this year. Those employers that wanted to offer a private plan to their employees, they started to submit those applications in February and March. Quarterly electronic payments of contributions that have been withheld are due no later than 30 days at the end of the quarter. We already have contributions coming in now, and all of them will be due. That first stream of that first, I should say, tranche of contributions are due in April on the 30th of this month. In December, our goal is to be able to start taking applications for paid leave benefits that we hope will be payable starting in January of 2022. Which employers are covered by the paid leave program? You are a covered employer if you have 1 or more employees working in the state of Connecticut, and that includes a not-for-profit entity or private sector employers that have unionized workforces. If you are a sole proprietor or you're a self-employed individual, you do have the option of participating in the program, but if you choose to opt in, you do have to do so and remain in the program for 3 years. Those employers who are not covered include the federal government, and some state of Connecticut employees. Municipalities and local or regional boards of education are also excluded unless they too have covered public employees, which I'll define in a moment. But all non-public elementary or secondary schools, often known as public, parochial, or private schools, independent schools, are completely exempt from the paid leave program. Covered public employee is either a non-unionized employee of the state of Connecticut, or they're a unionized employee of the state that collectively bargains to be included in the program with their bargaining unit. Employees of municipalities and local or regional boards of education are generally not covered, as I'd mentioned earlier, unless the unionized employees of the municipality or the unionized employees of the local or regional board of education opt in by collectively bargaining to do so. If they do so, and they work for either the municipality or the local or regional board of education, then all of the employees in either of those workforces are included, whether they are in the bargaining unit or the union or not. And you can see that the definition of municipality is quite broad. It can include what we usually think about as a municipality, a town or a city or borough, but it can also include a tourism district or a flood commission. The contributions to the Paid Leave Trust Fund should have begun in January of this year. That was the start date for the withholding. The contributions are post-tax, and they are based on the wages that are calculated to determine what a person's FICA obligation is. But those contributions are capped at the Social Security maximum contribution amount of $142,800. Once those 0.5% wages are collected by the employer, they are submitted to the Paid Leave Authority along with corresponding wage information. We then receive those contributions and we validate the wage information from data that we will receive from the Department of Labor. Those contributions are deposited into a Paid Leave Trust Fund that is managed by the Office of the Treasurer. And the trust fund is what's used to pay the benefits for paid leave and paid time off. So let's now take a quick look at the Connecticut Family and Medical Leave Act as it currently exists and what it will look like in 2022. If you are an employer that has fewer than 50 employees or fewer than 75 employees, you probably don't have any familiarity with the paid leave, with family and medical leave at all. So this will just be a quick primer as to how it works. If you are an employer that is covered by the state's Family and Medical Leave Act right now, you're usually an employer that has 75 or more employees. And for those employees to participate in the plan, they had to have worked at least a year, did not have to be consecutive, and 1,000 hours for that employer immediately preceding the time that they would be seeking time under family and medical leave. And once they've done that, then they would be entitled to job protection, which is the ability to get their exact job or an equivalent job when they return from leave. But that wouldn't be a right they can exercise unless they've been with the employer for 12 months. Once they had done so, they would be entitled to 16 weeks of leave in a 24-month period or 26 weeks of leave if it was for military caregiver leave. And the employer could require the employee to use all of their accrued time in whatever form it comes in to cover all or part of the time that they are away on family and medical leave. The law will change in January of 2022, and it will now apply when that date comes to all employers with one or more employees. There will be no hours worked requirement in order for an employee to get access to family and medical leave benefits, and they will have job protection attached after 3 months of employment rather than 12. The time period in which leave can be taken will be 12 weeks in a 12-month period, with the 26 weeks of leave for military caregiver leave remaining the same. There will be an additional 2 weeks of leave that may be available if a person is experiencing incapacitation during their pregnancy, meaning they may be able to take up to 14 weeks of leave. And an employer can still require their employees to use their accrued time off, but they must allow the employee to keep up to 2 weeks of accrued leave for their use outside of family and medical leave. The reasons for leave that are noted in the statute, actually, this is an exhaustive list of all of the leaves that are, for all the reasons for leave that are in the statute. They include expanding or creating your family through birth, adoption, or foster care. You can take leave to care for a family member with a serious health condition or your own serious health condition, which can include serving as an organ or bone marrow donor or pregnancy, which is considered a serious health condition. There is special leave that's available, as I mentioned earlier, which is military caregiver leave for those that are injured in active duty. There's also qualifying exigency leave when a family member is called to active overseas duty. There is an ability to take time off under the statute so that they can tend to their affairs, childcare and the like, while they will be away. And what is unique to Connecticut's law is that a person can take up to 12 days of paid leave if they are a victim of family violence. What is the length of the leave and the paid leave benefits? As I mentioned earlier, there is a federal Family and Medical Leave Act that has criteria that allows a person to take up to 12 weeks in a 12-month period, with the 26 weeks of leave for caregivers for those who are caring for those who were injured during active duty remains the same. And the same is true for the Connecticut job protected leave when the law changes in January. And the same amount of leave is available whether a person is taking their Connecticut Family and Medical Leave with or without pay. The amount of time is still the same. If a person has a right to take time from their job and return to that role, there are a number of laws that apply to job protected leave. They include the federal version of family and medical leave, the state version, which exists now and will change in 2022, as I outlined earlier, workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and what is known as CFEPA, which is the Connecticut Fair Employment Practice Act, all require some degree of job protection be exercised by the employer if the person chooses to take leave under any of these laws. Now, none of those actually provide income replacement, with the exception of the Paid Leave Act, which will change next year, and workers' compensation, which still remains available for income replacement. What are the eligibility requirements for FMLA? As I noted earlier, there's federal and there's state. When the state law changes, there will be no hours worked requirement, and the person will have their job protection leave, meaning that for job protected leave, meaning that if they leave for a family medical leave reason, when they come back, they are entitled to get their job or a significantly equivalent job back. But in order to get paid leave benefits from the Paid Leave Authority, they have to meet certain criteria, and they have to have earned at least $2,325 in the highest quarter of the past and of the 4 of the 5 quarters immediately preceding the time that they come and apply for leave. They have to have a qualifying reason and have leave time that's actually available. That earnings number I mentioned can be earned by one or more employers. Now, they can either be currently employed and working in the state, or if they are unemployed at the time that they apply for leave from the authority, they had to have been working in the state in the 12 weeks immediately prior to the time that they apply. A sole proprietor or a self-employed individual has the option of participating in the program, as I said, but if they do so, they have to remain in for 3 years, but they then would also be eligible for paid leave benefits like every other person that's participating. One of the other primary differences between our federal family and medical leave and our Connecticut law is what will now be an expansive definition of family member. Under federal and state FMLA, a person can take leave right now to care for a parent, a spouse, a child if that child is under 18, or if they're over 18, they may only take leave to care for that child if they have a disability. Under the Connecticut law in 2022, an employee will be able to take family and medical leave and receive paid leave benefits for a much wider number and types of relationships with people than exists now. They can take it for a parent, a spouse, and the age limitation for children is removed come next year. They can also take it to take care of siblings, grandparents, grandchildren, or any person with whom they have a relationship that is equivalent to the relationships that are listed here in the statute. And that is known as related by affinity. And that does mean that it's a relationship with any person with whom the employee has a significant personal bond that's like family, regardless of the biological or legal relationship. And of course, that is situational. It's specific to that particular person's circumstances. But we probably, in our circle of family or friends, may know someone who perhaps is in a relationship with someone and they're living with them as if they were a spouse, but they are unmarried. That spouse may become ill or need support in some way, and as the law stands today, the other person who wants to render that aid would not be able to do so without accessing their paid time off in some form, and they would be ineligible to access any family or medical leave benefits. Starting in January, that will change, and that person in that spouse-like relationship will be able to access family and medical leave and also access wage replacement from the paid leave authority for the time that they'll need to take to care for their loved one. So how does this work when an employee comes to you and asks for time off? If you've not used family and medical leave before, there are two questions that need to be asked. You're going to ask whether or not, depending on the size of your employer, your workplace, if the employee is eligible for job protected leave under one or more of the statutes that I listed earlier, and whether the person is eligible for any income replacement while they're out on leave. Because, for an example, if a person is eligible for job protected leave as a reasonable accommodation under the Americans with Disabilities Act, as an example, they would not necessarily be eligible for income replacement because the ADA doesn't offer income replacement. So that's why asking and answering both of these questions is important. As I just mentioned, that an employee could be eligible for state or federal FMLA only, maybe both of them running concurrently, maybe neither of them, given the example that I just provided, or they may not have any job protected leave at all, which is why it's important to ask those questions. So a few questions that we get about income replacement that I just wanted to review. A person can receive benefits from their employer through short-term or long-term disability or any other bank of time or wage replacement that might be available, and also receive benefits from paid leave. But those two sources of wage replacement combined cannot exceed 100% of the employee's regular wages. Generally, there are some short-term and long-term disabilities that require the person to exhaust their state accessible benefits first, and that is certainly permissible under the statute as it's currently written. If a person is receiving workers' compensation or unemployment, I should also include that here, then they are not eligible to receive paid leave benefits while they are receiving those other benefits or wage replacement benefits. Now, a person could possibly have eligibility for paid leave without any job protection. And that's because in order to get your paid leave wage replacement from the paid leave authority, you have to have made that 2325 I've spoken of. You have to have a reason for taking the leave that's covered by the statute, and you have to meet those employment criteria, either currently working or you had worked in 12 weeks before you apply for leave, for paid leave benefits. You could meet those criteria having worked at another job, but then come to your new job and ask for time off because you need it, you have to have surgery, and you've only been through your employer for a month. You don't have any job protection with that employer because you've not been there for 3 months, but you are eligible for paid leave benefits. And under those circumstances, the employee should have a conversation with their employer to make sure that they have a job to return to, although they're eligible for their paid leave. Okay. So how does a person apply for benefits from the paid leave authority? They come directly to the authority. This is not a process in which the employer needs to be involved as a gatekeeper for the initial application for paid leave benefits. When a person comes to us, we are going to determine their eligibility, including the reasons why they're seeking leave that's covered by the statute and whether or not they've met all the other criteria that I outlined earlier. We do a preliminary calculation of their paid leave benefit amount, and then we do have quite a bit of communication with the employer to make sure that the employee has made their employer aware that they will be away, that those absences are covered, or to see if there are any other benefits to which that employee may be eligible for that the employee may be eligible for that may offset the amount that they're seeking from the authority. And then once we've done all of that, then we provide the paid leave benefit to the person. And exactly how much does the person get? Well, it really depends on how much they make, as it is determined on a sliding scale. So if the person makes less than or equal to the minimum wage multiplied by 40, and as we sit here today, the minimum wage is $12 an hour, then that person would receive 95% of their base weekly earnings. If a person makes more than that, then the formula is a bit more complicated, and it's really better to show by example, so I'll show it on the next screen. But the maximum amount of money that anyone can get is 60 times whatever Connecticut's prevailing minimum wage is at the time. So right now, the maximum benefit would be $720. So here are a couple of examples. On the left, we have Mike, who makes less than or equal to the minimum wage multiplied by 40, because he makes $375 a week. His formula is pretty simple. He will make 95% of that, and that is $356.25. Deborah makes quite a bit more. She makes $700 a week. So she is entitled to start with the 40 times the minimum wage. So she starts at 480, and then she gets the difference between what she makes each week, the 480 times 60%. And in her instance, it's $132. So she gets 480 plus 132. So she receives $612 a week in paid leave benefits. All right, so I'm going to just kind of skip through these, and I'm going to go to spouses who work for the same employer, which is often the case with very small businesses and large ones as well. Under federal and state family medical leave, if a person is taking time off to care for a child who's new to their family, under federal law for care for a parent, under state law to care for a family member, they now have to share their 12-week job protected leave. Under the paid leave law, the spouses are not going to be required to share their 12-week benefit for any reason. I'll talk a little bit about private plans. As I mentioned earlier, the statute allows an employer to create their own version of the paid leave law, subject to the statute, and not collect the 0.5% to be remitted to the paid leave authority. If an employer chooses to do so, then they are responsible for administering the paid leave benefits. And while those contributions don't come to the paid leave authority, if an employer chooses to withhold a portion of those wages for paid leave, it cannot exceed the 0.5% that the state would withhold, and that money can't be used for any other purpose other than administering the plan or paying benefits. If an employer wants to apply for a private plan, they can do so by going to the paid leave website, ctpaidleave.org, and selecting the radio button that says, I want to apply for an exemption. If you, as an employer, choose to do so, you must meet certain criteria. The plan has to offer the same or better benefits as the public plan. Generally, a short-term disability policy does not meet those criteria because it would not cover absences for all the reasons listed in the statute. It may not cover the same amount of benefit amount, and it does not allow employees to vote for the plan because employees must vote, and it must be approved by a majority vote of all of the employees working in the state, and it has to cover all of the employees. And again, it can't cost more than the public plan of the withholding of 0.5%. There are a number of private insurers who are offering products for private plans in the marketplace, all of which are, we have 270 employers who have applied for a private plan. All of them have used virtually all, at least one of them has used all, every employer has used at least one of these companies in order to purchase a private plan for their employees. In order to do all of the things that I've just spoken about, one of the things that we're really asking employers to do is to register your business, because it's the only way, unless you're using a payroll company, to remit your employee contributions, which are due at the end of each quarter. We know that employers are required to withhold 0.5% of wages, and if you're not registered and you're not using a payroll provider, you won't be able to remit those contributions. They can't be mailed in, and they cannot be sent to the Department of Labor or the Department of Revenue Services. The inability to mail them in is for security purposes. We are not in a physical building. And we don't want anyone's checks or credit card information going any place where anyone can get their hands on it. So that is why mailing in payments is not an option right now. Registration process is really very simple. You just go to our website, and it's one of the first things you'll see as soon as you get on that landing page, and it will walk you through the process step by step, including a checklist that you can look at. So you can gather the information you need before you register, and a video that you can watch that will show you the entire registration process from beginning to end. So what should you do if you haven't started withholding contributions or your employer hasn't started withholding? You should start now. There is something called the catch-up period, and that has been negotiated with the Department of Labor so that businesses may withhold through June of 2021, retroactively to January, an additional 1% on top of the 0.5% if the employer has not withheld any contributions to the paid leave trust fund from their employees. What we tell employers is that if they choose to use this catch-up period, to please inform their staff, because they do call us or they email us if the withholdings don't match the 0.5% that they were expecting from their checks. We've just learned today that the Department of Labor is extending the catch-up period through September of 2021 to give employers and employees more time to be compliant with the paid leave statute. We often get this question: what are some of the possible consequences of not withholding? So if you haven't withheld, you're not using the catch-up period, and you're just simply not contributing, and you're not one of the employers that are part of the exempt list of employers, then your business will be responsible for making up those missed payments from the employees. And it can affect their ability to receive benefits, because we do ask whether or not the employee has made a contribution. We do, under statute, have the ability to impose more additional monetary penalties for failure to withhold, but we do feel that having the responsibility of making up those contribution payments on in and of itself is a pretty significant consequence, and hope to not have to find ourselves in a position where we have to impose additional monetary penalties. So I've spoken about a lot today, and I will actually commend each of you to our website, which is ctpaidleave.org, where you will find an abundance of information. You will see here that we have an employee rights poster, which is a very comprehensive summary of everything I've spoken of today that can communicate this very clearly to all employees. And it's not just available to employers. Anyone can download this and use it for their own use. There's something we call a rack card, which is just a smaller version of the poster. And on the far right, you'll see a fact sheet, which is yet another version of the information. We find that people take in information differently, so we've presented it differently. There is, if employers have not begun withholding, excuse me, there is an employee paycheck mailer that you can use, and it does say in January, but what we found is that employers who have not started their withholding are actually downloading this, adding their own email message to it and emailing it to their employees if they're not back in their workplaces to any significant extent. The employer toolkit is the most comprehensive document that we have that includes everything that I've spoken of today, including private plans and withholding and everything else. It's all right there in one place, so that you don't have to search the whole site if that's not something you're interested in doing. Again, our site is ctpaidleave.org, and there are 4 actions that we're asking employers to take today, or employees to go back and ask their employers to take, which is to register and to start withholding of the wages. If you're using a payroll provider or any kind of third party, a tax accountant or anyone, make sure that they're processing those wage withholdings and they're remitting them to the Paid Leave Authority Trust Fund, because they're due in just a few weeks. To educate yourselves and your employers about paid leave, and to visit our site regularly for any updates. We are here to help. We do not have a call center, but we do have a contact us feature on our website with support that will get back to you with any questions or concerns that you might have. There are also frequently asked questions and helpful videos that are on the site as well. And we ask that people just use them as much as you can, and let us know if you have any further questions. So I'll stop my presentation there and stop sharing. Turn my video.
Thank you, Andrea. So we
Yeah.
do have a couple questions in our Q&A. The first one is, as a sole proprietor, if I were to get sick and have no short-term disability or long-term disability benefits, would I qualify for Connecticut paid leave?
Okay, so you broke up a little bit there, Amber. So, I mean, could you repeat the question?
Sure. As a sole proprietor, if I were to get sick and I have no short-term or long-term disability benefits, would I qualify for Connecticut paid leave?
You would qualify if you have signed up for paid leave, you've been making the contributions. You don't need to have short-term or long-term disability. Some sole proprietors and self-employed individuals have it as a supplement. Let's say AFLAC, I think is the one that most people are most familiar with. But if you have a qualifying reason for leave, you've signed up for the program, you've been making your contributions, then yes, in fact, you would be able to qualify for paid leave.
Okay, thank you. And this one is in regards to a university. So the University of California is a public university, and we provide our own family paid leave to our employees. Are we subject to Connecticut FMLA?
And not unless you have any employees that are working in the state of Connecticut. And we do have a number of, let's see, regional, national, international, multinational organizations that do have employees that work in the state. So you are subject to pay leave if you have employees for whom you, for example, issue a W-2, have a payroll or other tax obligation in the state of Connecticut, or you have an unemployment insurance obligation for that employee in the state, then you would have that obligation for those employees that work in the state of Connecticut. For any others, you would not.
Okay, thank you. And the next question is, if our payroll system has not withheld the deduction for the first quarter of 2021, what should we do in terms of reporting and payment?
All right. So I think this is the question of has there been just no withholding at all? If there's been no withholding at all, then you do need to calculate retroactively to January and then remit those payments to the paid leave authority. If you need to use the catch-up period that I spoke of that has now been extended through September, then you can do that. And you can then, but you should remit whatever payments you think that you can collect by April, and then you need to continue to use that catch-up period so that you can remit by the end of the next quarter. If the payroll system that you're using, I don't know if it's a third party or if it's internal and it's your own, we do know that we've spoken to Intuit, which owns QuickBooks, and they have made this change in September, or actually I think it was more like October or November. They have made that change. So if you use QuickBooks and that hasn't been an upgrade or change that you have had access to, you should definitely communicate with them. We don't really have any other knowledge about any other software programs that should have made the change but didn't. That's the only one that I know of. But in a nutshell, if you haven't started withholding, you need to start right now, and you need to get caught up as quickly as you can. And if you're still having challenges doing that, then you should get in contact with us at the authority so that we can help you work through that.
Okay, thank you. And the next, a qualifying illness is subject to approval. So who decides if it's a qualifying illness? Is there a complete list of qualifiers? And if so, where could this be accessed?
Mhm. Right. So the qualifying reasons for leave are let me just go back to that slide for a moment because that might just be easier than me walking through them again. Oh, let's see.
And just for our folks out there, I just want to let you know that the chamber will be receiving a PDF version of this presentation, should you be looking for a copy.
Okay. Thanks for that, Amber. I'm going to try to share my screen again. All right.
Okay, we can see it.
Great. Thank you. I'm just going to show it from the current slide. It does not want to cooperate today. So let me just scroll back to it. It doesn't want to do what I need it to do. So I apologize for the scrolling, but apparently it just does not want to be cooperative. All right, so here we are, finally. This is the universe of qualifying reasons for leave for family and medical leave. Let me just be really clear about this. It's family medical leave and paid leave benefits. And the reason that I make that distinction is this, that any employer of any size, meaning one or more employees, will be subject to family and medical leave under the statute when it changes in January of 2022. And whether the person gets paid for that leave is something that's decided on the paid leave authority side. So the reasons that a person can access family and medical leave, whether they're paid for it or not, are these: to create and expand your family, caring for a family member, your own serious health condition, military caregiver leave, qualifying exigency, and family violence leave. So as an example, if someone were to come to you, or you were to go to your employer and say, I have, my brother needs a kidney, I'm a match, I am going to donate a kidney to him, but I don't want to use up my vacation time. Let's say that's one of the requirements that your employer has, is that you can take the leave, but they require you to exhaust all but 2 weeks of your vacation time first. I don't, want to use my vacation time, or let's just, or any other reason, then that person is entitled, as long as they have a qualifying reason for leave, to take that family and medical leave. Then the next question you ask yourself is, are they eligible for any income replacement? And that can come in the form of being required to use all but 2 weeks of their vacation or sick time, or if they don't have any that they can use without getting down to less than the 2 weeks, then they can come to the paid leave authority and get paid for the time that they'll be out to donate their organ to their sibling. So I want to make sure that people aren't putting those two things together, because that's not the case. A person would be entitled to leave, whether they get paid for it or not, come January of 2022, if they're taking it for these reasons.
All right, thank you, Andrea. I appreciate that. Who could we contact if our bank has an issue with our ACH credit format requirement? We have tried to contact us, but the communication has not, I don't believe they've had a follow-up yet. So I would like to ask this person if you could please submit your email in the chat for me.
Mhm.
And what I will do is I will get your contact information over to our contact team so that they can follow up with you immediately. The next question is, if an employer has employees in New York, Florida, and California working remotely, but W-2 wages are filled out in Connecticut, are the employees covered under Connecticut paid family medical leave? Do they have to contribute to the state fund?
All right. I'm going to actually read that question again, and because for some reason you keep going in and out, so I'm not getting all the questions
Oh,
of
okay.
the question in its entirety. So let me see. The way that I'm reading the question is, if an employee or has employees in New York, Florida, and Connecticut working remotely, but their wages are filled out here. Okay, so now I think I understand the question. If they are working remotely because of COVID, but they would normally work in Connecticut physically, or you still have an obligation for them as a Connecticut employee, as I mentioned earlier. So if you are obligated to pay for unemployment insurance compensation for them, you have a payroll tax obligation for them in this state, you're issuing them a W-2 that is commensurate with wages that they earn in the state of Connecticut, we consider them employees under the statute, and they do have to contribute, but then they're also eligible to apply for benefits when that time comes. If, for example, which is very, very common now because of COVID, there are people who would normally work in the state, but they are wherever they are, right? They could be anywhere in the country, but they would normally come back and work in Connecticut. They are still considered Connecticut employees. The Department of Labor has not changed that criteria, and they are still obligated to participate in the plan through making a contribution. All right. So then I see the next question is, what is a serious health condition? All right, a serious health condition is one that affects your activities of daily living. So here's an example. I get the flu, it turns into pneumonia. I am now hospitalized and I can't come to work. That is considered a serious health condition because it affects my activities of daily living. I can't necessarily get up and go to work. I might have trouble making my way to the restroom because of physical weakness. Or I'm on a respirator because I have pneumonia and I can't breathe. So that's considered a serious health condition. Pregnancy statutorily is also considered a serious health condition. There is a definition. It is we at the authority do not define what a serious health condition is. It is a statutory definition under the State's Family and Medical Leave Act and under federal FMLA. There is not a comprehensive list of what serious health conditions are, because it needs to meet that definition of having that significant impact on your activities of daily living. And not only a doctor, but a healthcare provider, meaning an APRN, could also, a physician's assistant could also make that determination. And there is a comprehensive list of healthcare providers in the statute that includes practitioners of Christian Science and, as I mentioned before, APRNs, chiropractors, healthcare professionals generally, who can make that decision of what a serious health condition is. But you're not defining that or determining that. That is something that is determined by that person's healthcare provider through a medical certification that they have to take to their healthcare provider and have completed, and submit that in order to get their leave and their paid leave benefits.
Thank you, Andrea. The next question in regards to wage reporting file specification. 1, is there an option to report wages using Excel file or an employer with about 50 employees? 2, what are the enrollment and return files in file specification toolkit? They're having challenges setting up wage report using that file. And
Okay.
3, how would they submit, enroll, and return files if they use file and pay?
All right. So all of the wage reporting file specifications are on there. They should be on our site. And if they're not on our site, then they are on the Department of Administrative Services site. If you look up paid family and medical leave, excuse me, because that is the one place where we could put them that we knew that everybody would start to look for them, and that we could put it where people would be able to access it regularly. And if these specific questions, I would need the person to provide Amber with their email address. We can forward that to our IT team and they can give you the wage reporting file specifications, but they are clearly defined and available. So we can get those to you.
Okay, thank you. To that person with the question, I did just drop you a note that if you could send me your email in the chat so we can follow up with you, that would be great. We don't have any other questions at the moment, but if you do have questions, we still have time. So please submit your questions using the QA feature at the bottom of your screen. In the meantime, I will be dropping a couple of links in our chat, including our YouTube page, where we have several other recorded webinars on several different topics, so you can utilize those.
I am not seeing any other questions. So Vera, not sure if you'd like to wrap things up. If you're still there.
I am still here. No, this has been great. Thank you so very much, Andrea.
You're very welcome. It's our pleasure.
Yeah, it's been great. And thank you very much to the Connecticut Paid Leave Authority for this informative presentation. And thanks to each of you in attendance today. As mentioned earlier, this presentation has been recorded and will be available on the Chamber's social media platforms. So be sure to follow us on Instagram and LinkedIn and like us on Facebook. And please visit our website at bloomfieldchamber.org for a complete list of upcoming webinars and activities. Again, if you have any questions, please reach out to Andrea and her team. Thank you all very much for being here today, and we look forward to bringing you more quality programs like this in the future.
Perfect. All right, have a good day, everyone. Thank you. Thanks for having us. Okay, bye.
Bye-bye.